Today we're going to talk about valuation. And this is a really hot topic when it comes to trade secret risk management and mitigation, right there along with the identification of assets. And the reason that there seems to be a lot of discussion about this is because 98 or 97, something like that, percent of companies do not currently value their trade secret assets. Most companies don't even identify their assets as trade secrets before they necessarily have to when litigation comes, which is, in our opinion, not the best risk management strategy because should always identify and put a value on the risk before you determine what countermeasures to apply. And I do think that based on the couple of seminars that I've attended recently, that were trade secret specific, where there were judges on the various panels there, that the thought and the thinking behind that is dramatically shifting in favor of identifying and putting a value on trade secrets up front. Because I do think that it helps the argument that once you've done that, you can put proper countermeasures around them and show that you were using reasonable measures. Another reason I think a lot of organizations do not put values on trade secrets is because they didn't realize that it could be done. And we're going to talk a little bit more about that in a minute. But just as a reminder, trade secret misappropriation claims are very significant. They're expensive and they take a long time to litigate, on average 2.7 years when a case goes all the way to trial at a cost of $4.1 million in legal fees, not necessarily including all the damages experts and others that might need to be hired along the way. If the trade secret is valued at more than 25 million, the amount of the money expended and the time expended is much more significant than that. And some of the trade secret misappropriation claims have settled or ended up with final jury verdicts in the $2 billion range just in the last 3 years. Another case in point around the changing and dramatic impact trade secrets are having today as a part of IP portfolio is the difference in the number of claims that were brought in 2016 versus 2020. If you look at the Stout report, and I think a lot of that is because the DTSA passed in 2016. Those numbers are increasing every year, and we're starting to see a lot more organizations focus on trade secret protection. Can you value a trade secret? This is a question we get asked a lot. How do you value something that a significant portion of the value is on the future sales of that asset? But certainly trade secrets can be valued. They're valued every day by folks in the intangible asset valuation world who look at all manner of intangible assets for tax and accounting purposes, for M&A due diligence purposes, and just to put, a value on the goodwill or intangible assets that are carried on a balance sheet. Unfortunately, GAAP accounting has not really kept up in the United States with the value of these intangible assets, specifically intellectual property. And so right now, trade secrets are not scheduled as a separate item on a balance sheet. But that doesn't mean you can't value them. And in fact, you need to value them on a go-forward basis. There are several methods that are used by these experts. Oftentimes, they are doing evaluation on an entire IP portfolio, including patents and other types of intellectual property. Very rarely do organizations get asked only to look at trade secrets, but that is in fact what we're doing. And if you've been following along with our process and the way that the methodology that we've developed at this stage in the game, you would have obviously pre-identified the assets that you believe to be trade secrets, and you would have done the 6-factor litmus test to determine whether or not they would likely succeed had you brought a claim for litigation around the protection of that asset. Once it's determined that they are trade secrets, that's when we bring in an independent third party to help us put a value on each individual singular asset so that we can then schedule the value of that asset with a brief description of it on the policy wording. And that becomes the value or the limit established at the beginning of the policy period.
Mary, sorry to interrupt.
Yeah.
Do you mind if I just ask a question on that?
Yeah,
What's the sort of typical norm for a company that hasn't had a third party value their trade secrets? Do they tend to try and estimate themselves and put something on on their balance sheet, or do they just leave it completely unspoken about? Or what do people do today that haven't had a third party, that aren't going through a M&A sort of situation at the minute?
most of them do not put anything at all on their balance sheet unless they've had maybe somebody look at their patent portfolio and or they are licensing some of their patented technology to third parties and earning licensing revenue on that. And then they can put an asset, they can account for the valuation of intellectual property assets that they're licensing to third parties. Otherwise, it ends up being a goodwill item on the balance sheet only post acquisition. So if your
Gotcha.
company is sold for more than your revenue or 5 times EBITDA or whatever it is, and so one company clearly paid something for the value of assets or sales that don't yet exist, then you can associate some that goodwill number with the overage between your revenue and what the company sold for. I'm very much oversimplifying this because I'm not an
Yeah.
accountant, but that ends up as a goodwill number. But almost no company that we speak with, to be honest, actually looks at their trade secret assets as a standalone valuable item. And I think a lot of that is because they don't know that it can be done, and or that there hasn't been insurance behind it, which means that you can't get, you up until now you weren't able to get loans around it or speak to your investors around the value of those assets. But now that game is changing and you can insure them, obviously. And hopefully you'll be able to speak to investors and potential lenders about that valuation so that you can use the insurance proceeds that represent that value as collateral to get a loan. We think that's going to be a game changer and one of the reasons why it's important to do a valuation of your IP assets, for a lot of different reasons, actually. But that's really what this slide is talking about.
Okay, cool. Thank you.
Mhm. The second bullet point on the right on this slide, I kind of talked about the other two items already, is that trade secrets can include other types of IP, which I think is another misconception, including patented technology if it's part of a business process trade secret. For example, if you have a manufacturing floor set up with a bunch of patented technology all over the floor, whether it's yours or somebody else's, there'll be all kinds of machinery and equipment on the floor that has been patented for a long time. But the trade secret that you own is the way that your manufacturing floor is set up, for example, to use and produce much less waste, or to just get packages out the door a lot faster and they weigh less, or whatever it is that gives you that competitive advantage. That business process that determines or actually operates the speed and the temperature and the methodology that you're using to gain that efficiency is a trade secret. So when the valuation person comes in and looks at the value of that asset, they have to try to strip out, independent of the rest of the IP or the other assets that might be part of that business process trade secret, what that value is, and put a standalone number on just the trade secret part of it. It's by far the most difficult asset to value as a combination trade secret, but it still can be done. And for that reason, oftentimes when you get an actual valuation, especially on a combination trade secret, you will get a range of that value. So the valuation person might come back and say, based on all of the homework we've done, and we'll talk about the methodologies in just a moment, we think this trade secret today, as a fair market value as of a point in time today, is worth between 35 and $50 million based on how much time and energy and effort you put into the development of that trade secret, but also the useful
Yeah.
life of that asset over the future value of the asset brought back to net present value. But essentially, if they give us a range, we obviously are going to schedule the lower value of that range because so much of the valuation in trade secrets, especially young trade secrets that are not already in the sales out there being sold as a product, it's speculative. And so you have to be a little bit conservative. Does that mean that you're stuck with that valuation forever and that you couldn't argue for a bigger number when you go to sue for damages? Absolutely not. That's another question we get a lot, and we'll get to that in a second. Go ahead, Lindsay. So how does this tie into damages? So because this is a first party policy, remember, it acts like a crime or a property policy or a cyber policy, one of those on the first party side, meaning we're covering the value of the asset and the expenses that it costs to try to recover and mitigate the losses that result from the theft of that asset in the first place. In other words, if we can recover the asset and put the genie back in the bottle, then we've cured the impairment and there are no actual damages in terms of trade secret losses. Um, that does not mean that there aren't significant damages down the road. And so I just wanted to make sure that we explain that and that everyone understands the valuation we're putting on something is saying that, right now today, this mouse is worth X amount of dollars, but eventually, if it's misappropriated, we might argue some other things, which are listed here. First and foremost, in trade secret law, damages include mainly two categories. One is unjust enrichment of the misappropriating party, which usually comes in the form of costs avoided. So if I hire a couple of engineers who've worked on WD-40 formula all the way up to WD-38, which is a motor oil formula, they learned an awful lot making negative know-how, making wrong turns and tweaking the process and the formula and the heat and the temperature and whatever else around that asset during the development phase. So if I hire them, I don't have to start at WD1 or even WD15. I can start at WD35 or something based on the knowledge that these people are bringing with them to the table. So those are costs avoided. I don't have to do all that R&D. I maybe don't have to hire nearly as many people. That's a very common thing that's becoming more and more common in trade secret damages. And you can have unjust enrichment by itself without any other actual loss of income. That's a relatively new thing that the courts have been awarding and looking at just in the past few years. Also, training expenses, similar type of costs avoided. If I've trained and paid the salaries and benefits and spent a bunch of time and energy getting my people up to speed only for them to all walk out the door and go to a competitor, they've avoided that same cost and expense. They don't have to incur it. And so that is one form of damages. The next category is actual loss of income, which can come in really three ways. Actual loss of revenue dollars year over year or quarter over quarter, however you would quantify that, associated with somebody else having the keys to the kingdom and eating into your market share, which is the second part, a loss of actual percentage of market share that was expected or that you had been used to seeing. And then the third category, again, all under the loss of income section, is the loss of key customers. That was a really significant play in the Alcoa case that I talked about actually on the last Trade Secret Tuesday a little bit, and I wrote a blog about it because I thought it was super interesting. So two engineers had worked for former Alcoa subsidiaries. They left and went to work for a third company. That company was able to, supposedly based on the knowledge that those two engineers brought with them, take Boeing, which was the only client that Alcoa had for this particular type of really technical alloy that they were developing and manufacturing at the first facility. So they took the idea and know-how with them, but they also took the only client they had. That's significant, absolutely huge loss of market share. And that's really what they were litigating about. At the end of the day, though, and this is a really kind of very unique thing in intellectual property litigation and specifically trade secrets, if the case goes on for years and years because you don't have your ducks in a row, frankly, and you don't have the ability to present a really robust case around these were our trade secrets, here's how we protected them, here are the only people who had access to them, this was our independent know-how that we developed over a period of time. If you have to kind of recreate or invent that story and narrative going backwards. Once a claim has happened, it's going to cost you tens of millions of dollars potentially in discovery and litigation expenses, and take a lot longer for that case to get to trial. So fast forward, the Alcoa case took 8 years, ended in a 3-week jury trial in which Alcoa lost the argument that the 2 engineers that left took their trade secrets. After listening to it for 3 weeks, to the case for 3 weeks, the jury determined that it wasn't even a trade secret in the first place, because that information must have been known in the industry, and it wasn't something that they developed specifically for and out of their work at Alcoa. It's very difficult for a jury who is novices in whatever specialty you're talking about to look back 8 years prior and make a determination that something was not known at that time, unless you can demonstratively prove that you were developing it and all the wrong turns you'd made along the way. So the defense attorney was able to demonstrate or get them comfortable enough that that technology was commonly known in the industry enough that his people they weren't trade secrets when he brought them. And so end of story, they lost all of that money. They were suing for $256 million. They may end up filing bankruptcy, we don't know. And there have been some recent bankruptcy filings on the loss of trade secrets or trade secret misappropriation claims. So that is a really poignant example of why you want to document and be ready to bring a claim when you need to bring the claim. And then finally, the other theories, of course, if you're trying to argue after the fact, your trade secret has been misappropriated, there's no chance you're getting it back. It's now in the public domain, for example, and 5 competitors are making a product that looks just like it. Because maybe one of your engineers decided to publish a paper or something. Who knows? If it wasn't that obvious and it was an actual misappropriation event instead, then you would be claiming that your reputation was harmed and that your stock price dropped, in addition to all of the money that you spent training your people and the actual loss of customer income. So there are a lot of damages theories that are brought into play when you're trying to sue for damages on the back end. That's why when we talk about whether or not being stuck with the valuation that we give an asset at the beginning of the process is a problem, I personally have spoken to several judges at these conferences and told them what we're doing and said, if I were to explain to you and or a jury that we gave this evaluation kind of a floor as of a point in time without knowing all of the factors and the circumstances around the loss and or what it was going to happen to their reputation or their stock price or anything else, couldn't you see that you could argue for a much higher value in court when you're seeking damages? And they were like, of course. But some of the attorneys that we've talked to have really been hesitant to tell their clients to put a value on these assets because they're worried that somehow they're stuck with that valuation, which is just not true. And that answers the question that Lindsay so nicely put in the true or false box there. Next. Or any questions at that point? Anything else? Okay. So now these are the actual, oh, Stephen, go ahead.
No, I'm all good. No, I'm all okay.
Okay. So these are the various methodologies. I am not an accountant, let me just say right up front. So I'm probably not going to do these justice, but essentially, whoever is looking at the valuation around these assets would use these very well-established accounting methodologies that they use to value patents and other types of IP. They've been stood up in court for decades now. They're used and accepted by all of the major accounting firms. So it's not just some pie in the sky, approach that these people are taking. Where there are some liberties based on the expert that you hire is which method they use and what types of research they do on the back end. For example, they might look at various indices in the tech industry to see how much, if you were to patent something very similar, that technology was being sold and licensed for, so that they could put an appropriate value on that, and they may get a different number than the next person, but essentially they're using the same methodologies anyway. The 3 most common methods are all about various types of the income approach. One is, and essentially they would use one or the other of these depending upon where the asset is in its development life cycle, if it's already being sold or not, if it's still in R&D and hasn't made its way into the public domain. Um, Essentially, you can look at the actual earnings over a period of time. That's the easiest thing to do. And projected earnings, if it's something that's being sold already, like WD-40, for example. You can also use the relief from royalty method, which is very common in patents, where you would look at an asset as though it were being licensed, to see how much money you could have generated potentially on the basis of licensing that asset, to make an argument around the relief from royalties. The with and without method is something that is more commonly used when the asset is an efficiency gaining asset as opposed to a revenue generating asset. So if it's a logistics or supply chain function that just makes you faster and a lot more competitive than the next guy, they would look at your ability to sort and ship packages with this technology and without it, essentially. And then the fourth category is for companies that are really just starting up, and that are having a hard time convincing somebody, about the potential revenue, of an asset that they're working on, or an innovation asset, because it's something that's never been sold before and we don't know how big the market is or whatever. In that case, you might just look at the cost approach. How much did it cost you in R&D, and how many resources did you spend on this? All of that is to say, this is not a science, but there is a lot of science around the art. And these are defensible numbers, and there is some back and forth potentially with the insured and with the valuation company on, maybe you missed this aspect of it, and here's why we really feel strongly that the number should be Y. But at the end of the day, we want this to be a very unbiased, opinion around the valuation of these assets. Next, Lindsay. That's really it for my prepared remarks. Trade Secret Tuesday, the next one is about reasonable measures, which could be really cool and really fun because reasonable measures are changing all the time. Just in terms of what people expect, here's a hint. Up until now, in trade secret litigation, there's been almost no expert testimony from cybersecurity specialists, which is interesting to me. As a cybersecurity person by background, I think that's going to dramatically change in the next 24 to 36 months. It's going to be much more difficult for people to argue that just because they have very standard encryption and things, that they are using reasonable measures to protect their trade secrets. That's just a little preview, and I probably will be wearing a costume or something, so that'll be fun because it's Halloween. So I hope you can join us.